Hello, I'm Ken Carlson. I've been an attorney helping tenants since 1980. I'm a graduate of UC Berkeley and Loyola Law School. I operate the caltenantlaw.com website, where you will find this and other videos, as well as lawyers to help you. I enjoy empowering you. With the economy collapsing and foreclosures increasing, tenants are facing eviction by the banks when you've done nothing wrong. This occurs with a house or condo. Many people thought they would get rich quick by buying houses to rent out, only to find out that they couldn't keep up the payments. Your advantage of being a tenant in this situation is that special laws protect you. Where the landlord falls behind on his mortgage payments for a few months, the bank files and serves a notice of default, which you would probably get by certified mail. 90 days later, the bank can serve the notice of sale in the same way, setting a foreclosure auction hearing date and place. Someone, including the bank itself, buys the property, and then they are the new owner. Whoever buys it wants you evicted so they can sell the empty property at a huge profit. It's called flipping. Once the sale occurs, the buyer has to record their new deed and only then serve the eviction notices. The former owner only gets a 3-day notice to quit, meaning move out, if he lives there. However, tenants of that former owner are entitled to a 90-day notice to quit under the federal Protecting Tenants at Foreclosure Act, the PTFA. That law also provides that if the tenant has a lease that is still running, they cannot be given that 90-day notice unless and until the new owner is, or has someone, ready to move into that house as their primary residence. That tenant can't be the parent, child, or spouse of the former owner, and must have a regular rental agreement at rent close to market rate. There are additional protections for you, such as California's Tenant Protection Act, the TPA, which requires the new owner to pay you 1 month's rent relocation assistance and identify that right in the eviction notice itself. Rent-controlled cities and those with just cause eviction laws may have their own set of conditions to evict you that must be met if the TPA does not apply to you. It sounds like a strong safety net, but the new buyers think they can scare you out and break all these laws, and if you don't handle it correctly, they will. My record for keeping such a tenant in possession is nearly 7 years without paying any rent. And he won. These new buyers and their lawyers are bullies, but they are stupid bullies. They make lots of mistakes, relying on corrupt judges to help them. The common mistakes are serving the notice too soon, not finding out if the tenant has a lease, not waiting to serve the tenant with the 90-day notice, screwing up on the TPA or just cause law requirements, filing the case too soon, not serving the notice to the tenants, and thinking that the tenants won't know how to stop them. That's on top of all the other mistakes they commonly make in an eviction. If the foreclosure sale has not yet happened, tell your landlord that his losing the property in foreclosure is a breach of his duty of quiet enjoyment and of good faith and fair dealing, for which you can sue him. However, he can minimize or eliminate his liability to you by giving you a 3-year lease, utilities included, and excusing the rest of your rent payments until the foreclosure sale. He's losing the property soon anyway, so he's not going to evict you for non-payment of rent because he can't get possession if he wins due to the foreclosure sale. But he can reduce his own liability by giving you that lease. The benefit to you is great because if you only had a monthly tenancy, the 90-day notice would start running right away. But with a lease, they can't even give you the 90-day notice during your new lease, unless, as I said, they or someone else is making your house their new primary home. Since the object of the buyer is to sell an empty house, they don't want you as a tenant, and therefore they refuse to accept rent from you. While you are fighting this eviction, for maybe years, you pay no rent by their choice. The new landlord remains liable to you for habitability defects, continuing to pay for utilities if that was included in your lease, and after you win, you can sue that new owner and his lawyer for malicious prosecution, retaliation, and other things. Their arrogance blinds them to that probability. They almost always start with a combined 3 and 90-day notice of termination, the 90-day portion being for you. They never bother to stop by and ask if you have a lease or get a copy of it. Sometimes they even order that you come to their office to prove that you are the tenant so they can yell at you and threaten you into giving up your rights. Don't go. Don't even respond to them. Sometimes they will offer a cash for keys deal, where if you vacate by a given date, they will pay you money. Don't fall for that, because they won't pay, making up some lame excuse that you didn't vacate on time, but thanks for the keys, sucker. Well, it is possible, but rare, that the offer is legitimate. You need the real protection on that, and a lawyer's participation in negotiating it. As your eviction case goes through what I call the game board, which you can find on my website, you will be catching them at every mistake, making them start over again and again. Common sense, business cost-benefit, and risk analysis should tell them that they have been caught trying to get away with an illegal eviction. It doesn't. Blind arrogance drives them forward. They try to scare you, but you're just laughing at them, knowing in advance the next pitfall that they will suffer. By the time it comes to trial, they are emotionally and financially exhausted. They have been paying the mortgage, property taxes, and utilities, even condo dues, plus their expensive but ineffective lawyer, worrying about how much it will cost to fix your house for sale, losing out their chances to sell the property while tying up their money in this sinkhole. The jury trial will cost them about $15,000 more, and their lawyer is telling them that there's a good chance that you will win. Even if they do win, they lost, and if they lose, they really lose, and have to start all over again with even less to work from, while you are suing them for trying to illegally evict you. They have been so beaten up by you that, as bitter a pill as it may be, they may have to make a generous offer for you to just leave so that they can continue with life. One of my clients was paid 10 months' worth of rent just to go in 60 days, and they took it. Did they win? There's a lot more to discuss, but you have a good idea. You can turn an "oh no" into an "oh boy" just because you had the courage to stand up to them all, use the right legal tools, and stick with it. It's all up to you.